Hello and welcome. You are watching IndianExpress.com. So, the Supreme Court on Thursday reserved its verdict on the quantum of punishment that has to be awarded to senior advocate Prashant Bhushan, who was held guilty of contempt of court over two of his tweets. Now, during the hearing, the court also asked Bhushan to reconsider his statements, but Bhushan refused to do so. Now, let's try to understand what happened in the Supreme Court from our colleague Anand Krishnan. Anand Krishnaji, what happened in Supreme Court yesterday? What did the bench of Justice Arun Mishra said?
So yesterday, Bhushan appeared before the court. He was also represented by senior advocates Dushyant Dave, Rajiv Dhawan. They also spoke for him. Supreme Court being on lockdown, being because of the national lockdown, Supreme Court is also not hearing cases physically. It's only hearing cases through video conferencing. So all these people appeared before the bench headed by Justice Arun Mishra over the virtual mode. Now, Dushyant Dave, they had already filed an application the day before. The day before yesterday, seeking a deferment of this hearing on sentence till the court decides till Prashant Bhushan can file a review and it's decided. But the court, so that was basically Dushyant Dave was there for. He raised this plea to defer it, but the court rejected it. Dhawan went into the merits of the case, but then he was more on how the court had not considered the reply filed by Prashant Bhushan, had not given it an effective consideration. But the court said we have relied on every portion that was before us. Other parts we didn't have to. Maybe if you want to, we will do that also. The court also urged. Meanwhile, Prashant Bhushan issued a statement. He had a statement to make to the court, wherein he the crux of the statement is that he has conveyed his disillusionment over the verdict, that he was pained, but he stands by his tweets, that he doesn't intend to apologize for the same. But the court asked him whether, it happens in all contempt cases, who gives the contemptor a chance to apologize. If there is an unconditional apology, the court usually does not proceed further. So the court asked him whether you need time to reconsider your statement. The court was also wondering if that statement would amount to an aggravation or whether it's just a defense. So anyway, the bench asked him if he would need time to rethink, but he was sort of firm and said, no, I wouldn't want to. Even if you give me time, it's not going to be any productive use. But the court said no, but it's our responsibility to give you time, so we give you time. And so they have now given him time till the 24th.
One thing was very surprising was Attorney General K.C. Venugopal trying to defend Bhushan, not defend but actually urging the court not to punish him. There should not be harsh punishment to Bhushan. How did this happen? I mean, because earlier also government had been very critical and had a very strong stand against Prashant Bhushan. In fact, in one of the case in February, they had asked for punishment for Bhushan. Now, sudden this change of mood and this change of heart for the government and K.C. Venugopal asking the court not to punish him. What do we take of this?
No. We have to be very specific here. Venugopal appeared as the Attorney General. He was not representing the government of India. A notice was issued in this matter to the office of the Attorney General. Every lawyer is an officer of the court. So the court can, whenever it wishes, call upon them to assist it. So that's what the court did in this case also. It asked the Attorney General to assist it. Attorney General appeared in the matter and he gave his view of the Attorney General, not the view of the government of India. So as we have done a story today, interestingly, though he asked for urged the court yesterday, though Venugopal urged the court yesterday not to punish Bhushan, he himself, Venugopal himself had in last February, in 2019 February, asked the court to take action against him for 2 tweets. That was in regard to the appointment of M. Nageshwar Rao as the interim director of the CBI.
Okay. In fact, I was here reading your story, and Rajiv Dhawan had actually told the Supreme Court that the verdict that you had given against Bhushan, that will be criticized in the future. What was court's reaction to that?
These are usual arguments. Bhushan, being a defense lawyer, he has to defend his case. So Bhushan was saying that the judgment is not fair, that it has its flaws, and that when it reaches various universities and academies, and when people will in the future look up to it or look into it, they will be very critical. They will find many flaws. And he said that some of the pages were a copy paste from a previous judgment, in which 3 lawyers were put up for contempt. But the court said it was a very amusing reply, I should say. Justice Arvind Mishra replied that, we don't mind fair criticism, so leave it to us. That was his reply.
So now, since the verdict has been reserved, what should we expect during the next hearing? I mean, what punishment can we expect the court will award to Prashant Bhushan?
See, the court has reserved its verdict, but it has also given him time for to think over it, and if he feels necessary, he can give an unconditional apology. But the time for that is only till the 24th. If he tenders an apology by 24th, they have said that they will list the case again on the 25th. Then they might, just forget things and things will be cool off. But in case if he stands by his words and doesn't want to apologize, then the court has already, as I said, the court has already reserved this verdict. It will straight away pass the judgment. And when a judgment comes out, the punishment can be the maximum punishment prescribed is under the law is 6 months in jail. So it can be anything below that. It can be one lawyer was punished for contempt last year, where he was given 3 months in jail, and his practice, he was asked not to appear in the Supreme Court for 1 year. So, but then yesterday the court has assured that it will not activate the punishment. Even if it awards a punishment, it will not activate the punishment till Bhushan files a review and is decided. So that assurance is also there.
Now, Bhushan on June 27 and 29 posted 2 tweets on his Twitter handle. In one of the tweets, Chief Justice of India S.A. Bobde is seen riding a motorbike that is Harley Davidson, and that tweet was actually commenting on the functioning of the Supreme Court during the lockdown. And in the second tweet, Bhushan has actually criticized 4 of the former Supreme Court judges. Now, Supreme Court found these tweets very objectionable, and it summoned senior lawyer Prashant Bhushan. Now, Prashant Bhushan was held guilty by the Supreme Court of contempt. Now, this verdict also resulted in a lot of criticism. Many people asked whether they have the right to criticize the Supreme Court judges or not, and there has been a question on whether the Supreme Court is above criticism. Now, we try to understand and analyze the judgment of the Supreme Court that was against Bhushan through our legal expert, Faizan Mustafa. Faizan sir, what do you have to say about the Supreme Court holding Prashant Bhushan guilty?
I have 2-3 things to say about this judgment. First, I am not comfortable with too much of discussion about criminal contempt. Criminal contempt means scandalizing the court. I think civil contempt is far more serious, where the court has given a judgment and order, and that judgment and order is not implemented or complied with. As many as 96,000 cases of civil contempt are pending. Most of these cases are against the government, as governments generally don't implement the orders given by the court. In criminal contempt, we emphasize scandalizing of the court by somebody's statement. I think just like sedition, mere statement should not constitute the offense unless it is coupled with violence. Similarly, in scandalizing of court, unless the statement leads to obstruction of administration of justice, it should not be punished as a criminal contempt.
Mr. Mustafa, what precedent this judgment sets, and can we say that a tweet of a person can really scandalize the Supreme Court?
Now, about yesterday's hearing, I think the point which Dr. Dhawan and Dushan Dave were making was simply this: how do you assess the bona fide of somebody? Here is a lawyer who has spent a lifetime in taking up people's causes. So his intent should be judged not by the reach of Twitter. In any case, Twitter's reach, if you look at the total population of the country, is very, very insignificant. His bona fide should be seen whether he wants an improvement in the system. And this is precisely the case. He is saying that many people are not getting access to the court. I feel the court must demonstrate maximum compassion and generosity. Justice Krishna Iyer has said judges in contempt cases should not be oversensitive. I think this is the case where judges have been oversensitive. They have given undue importance to these tweets, and so many people, rather than getting deterred. Yesterday, Justice Mishra also said he wants to punish because of deterrence. Deterrence means other people do not commit the same crime due to the sanctions or the punishment. As soon as the judgment came in, hundreds of people retweeted those tweets, even though the Twitter has removed those tweets. But there were people who were writing on Facebook and in other social media forums. Therefore, I feel that it had no deterrent effect. I feel that the court should earn their dignity, their respect through their orders and judgments.
Well, that's all for now. For more news and update, keep logging on to IndianExpress.com.